Okay, well, it is 2 p.m. Hello, everyone. Good afternoon. Welcome to Domestic Violence and the Legal System. My name is Sebastian, and I work in Programming Services at Broward County Library, and I'll be today's session moderator. This program is a service of the Broward County Board of County Commissioners. And before I introduce our guest speaker for today, I would like to review some WebEx basics. Many of them are probably some basics that you already know, but it'll be a nice little refresher just in case you have any troubleshooting issues. So if you do experience any audio issues, we recommend that you disconnect and reconnect your audio device. That is almost like a refresher for your audio and will allow for you to hear us better. So you will do that by following the instructions on the screen. You go to audio and video. That's a tab on the top left corner. Then you select switch audio. Then you disconnect, which is in red. And once it's disconnected, you will need to select your audio option and then reconnect it. If you continue to have any audio issues, we recommend that you switch your audio from your computer audio to your phone. And that's done following the same steps. You go to Audio and Video tab on the top left corner. You go to Switch Audio, Call In, and then you select View. After selecting View, a box with the toll number, access code, and a password will appear, and you will dial in those numbers and be able to hear us. If you have any questions or any issues with troubleshooting throughout the session, please feel free to put in the comments box to all panelists your issue, and I will be here to assist you with that. We also have the chat feature, so you will be communicating with us mostly through chat, and you will send it to all panelists preferably, so that way our presenter and I will be able to see it. And we will be hosting a short Q&A session after the presentation, and we will let you know when we open that session. So I will ask you if you have any questions, and I will be reading them to our presenter, Mindy. And now it is my privilege to introduce, our guest speaker for today. As a supervising attorney with Coast to Coast Legal Aid of South Florida, Mindy Jones has been representing victims of intimate partner violence in Broward County for 19 years. She provides holistic legal services to victims for a variety of their legal needs. Mindy is in her 4th term as president of the Broward Domestic Violence Council, an organization dedicated to reducing incidents of domestic violence in our community. She conducts trainings for various organizations throughout the state and county about intimate partner violence and stalking. Mindy has served as a co-chair of the Children's Services Council Domestic Violence Prevention Strategic Plan Committee and has served on the board of the Broward Victims' Rights Coalition. Mindy is a longtime member of the Domestic Violence Fatality Review Team, which reviews domestic violence-related homicides in Broward County and makes recommendations to the statewide coalition against domestic violence in an effort to prevent domestic violence homicides in the future. Mindy was recently awarded the 2019 Community Leader Award from the Broward Domestic Violence Council and the 2020 Ending Abuse Award from Jewish Family Services. Please join me in welcoming Mindy Jones.
Thank you so much, Sebastian. So today I am going to be talking about several things, which I laid out for you here. This is basically an overview of the injunction for protection process here in Florida. October is Domestic Violence Awareness Month, and so I also wanted to bring that to everyone's attention and let you know that there will be events throughout the month that you can find online at the Broward Domestic Violence Council's Facebook page, or Women in Distress has a Domestic Violence Awareness Month calendar as well. Today I'm going to go over domestic violence, a basic overview. I'm also going to discuss some of the frequently asked questions that we are receiving about changes in the process due to COVID. I'll go through the types of injunctions that are available for people to file and how to file those forms. And then I'll go through a little bit of the hearing process, and we will have time for some questions at the end, again, in the chat box. So basically, domestic violence is about power and control. and this is a power and control wheel. They make power and control wheels for all different types of community as well, because we know that in, let's say, the immigrant community, that different things can be used as a form of control over somebody who's also an immigrant. We have a power and control wheel for the LGBTQ community. There are different things that can be used for those communities. But basically what this wheel shows is that there's, a continuum where things can be used leading up to actual physical or sexual violence. Things like, saying, if you leave me, I'm going to take the children away, or isolating somebody from their friends and their family, using, psychological and emotional abuse, or threats that are verbal, economic abuse, controlling the money, not letting somebody have access to the money. Many of these things are said in a gender-specific way because we know that domestic violence does affect women disproportionately than men, but there are male victims as well. I do want to acknowledge that, but some of the language that's used on these power and control wheels is gender-specific, so I just want to keep that clear. But then these things, these controlling behaviors do escalate to physical violence. So in the immigrant community, there are threats like, I'll deport you, I'll have you deported, you'll never see your kids again. LGBTQ community, it's things like, I'm going to out you to your coworkers if they are not out, or to your family if they're not out to their family. With seniors, they rely, let's say, on a caretaker, an adult child to take care of them and give them their medication. They can withhold medication. So if you Google power and control wheels, you can really find all these different things and see what some of these different activities are. But a lot of times we hear, oh, it's because of drugs, or, oh, it's because of alcohol. And it's really important to understand that drugs and alcohol don't make somebody abuse another person. What they are doing is exerting their control over another person. And usually the physical violence happens when somebody's trying to maybe separate from that, and then the abuser is exerting that power over them. So, I use the example, I'm sure that, I would hope that many people watching this are able to, drink alcohol and not abuse their partners. People are able to use drugs and alcohol and not, hit their spouses. So it's not about that. Sometimes it could exacerbate an existing problem that's already there, but it's not the cause of the problem. So some of the frequently asked questions that we've had during COVID is, what can victims do? We know that a lot of people are now maybe quarantined at home with their abusers, or, have to, basically things are shut down. Where you're going to your home, but maybe your home's not the safest place. So number one, victims can always call 911 if they're in immediate danger. I know at the beginning of COVID, when things were shut down, a lot of people thought that they couldn't call the police if they were in danger within their home. So it was really important. We tried really hard to get the word out that you should still call 911 if you feel like you're in danger. The other thing is that if you know you're going to be quarantined at home with an abuser, then really have a safety plan. And so for assistance with safety planning, our certified domestic violence center in Broward County is Women in Distress. I have their phone number up. It's 954-761-1133. They can assist victims with a safety plan. And so that's, okay, my neighbor knows if I turn off the light outside on the porch that, I need help. It's let me have copies of all my important papers, at my mom's house. It's basically coming up with a safety plan. Who can I call? Where can I go? If I can't get to a phone, how can somebody call 911 for me? They can also contact their law enforcement-based victim advocates or the victim advocate at the state attorney's office, who can also assist with safety planning. So a lot of times, if there is already a pending criminal case, or if they've had involvement with their law enforcement department, they would know their victim advocate and be able to contact them. One of the things that is part of a safety plan is filing a petition for an injunction for protection. and then contacting our office so that we could represent the victim at the return hearing for their injunction for protection as part of the safety plan. So in Florida, we have 5 types of injunctions. The first is domestic violence. So a domestic violence injunction is for people who have had a domestic relationship. So that's spouses, current or former spouses, related by blood or marriage, residing together as a family unit, and that includes same-sex partnerships, whether they're married or not, unmarried couples who have a child in common, regardless of their living situation. And then domestic violence is defined as assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any criminal offense that results in a physical injury or death of one family or household member by another family or household member. So this is how the law defines domestic violence. So if you remember on the power and control wheel, there were many other acts of power and control besides physical or stalking or assaults, right? So those things the law doesn't recognize as domestic violence. And I know sometimes this is difficult for people to hear, but things like psychological abuse or financial abuse are not considered domestic violence under the injunction for protection law. There is now a risk protection order for a senior where maybe financial exploitation could be considered, but not under a domestic violence injunction. The next type of injunction is a dating violence injunction. And this is for people who never lived together. They don't have a child in common, but they did have a relationship within the last 6 months. And they had to have engaged in a continuous and significant relationship of a romantic or intimate nature. The violence is defined the same way as the domestic violence. So again, this is somebody who was in a dating relationship and one of those incidents of violence occurred during the relationship. There's also a sexual violence injunction, and that's for victims of sexual battery or lewd and lascivious acts. There's a stalking violence injunction, and that's for somebody who willfully, maliciously, and repeatedly follows, harasses, or cyberstalks another person. And they use the misdemeanor definition of stalking for this, so there does not need to be an actual threat. It's just the pattern of behavior with no legitimate purpose, which causes another person emotional distress. So again, and this could be through the internet, over the phone, text, or in person. So that's why you see that they include stalking or cyber stalking. There's also repeat violence, and this is 2 incidents of stalking or violence. And one of the incidents had to have occurred within 6 months before filing. And so we see this more typically with neighbors or coworkers or somebody with the ex-boyfriend of their, new girlfriend, something like that. A lot of times it's coworkers, people in like condominiums and neighbors, things like that. There's also petitions that somebody can file on behalf of their minor children. So if their child has been the victim of domestic violence, dating violence, sexual violence, stalking violence, or repeat violence, and they are still a minor, then a parent or legal guardian can file the petition on behalf of the child. So filing an injunction for protection, and I'm going to talk about this, how it is, and then also during COVID. So somebody can file for a petition for injunction for protection at the main courthouse, that central courthouse in downtown Fort Lauderdale on the 2nd floor, room 2140, or they can go to the West Satellite Courthouse that's in Plantation, and that's room 180. So at the central courthouse, they take filings in person till 5 o'clock. At the West Courthouse, they only take filings up till 2 p.m. And then they refer people to go to the central courthouse. If somebody wanted to file after hours or on a weekend, they would have to call Women in Distress's crisis line, and then they'll be asked a series of questions to see if they qualify for an after hours or weekend petition for injunction. All of the forms are available online. So if you ever wanted to look at the forms, and many times if somebody contacts us ahead of their filing, I'll send them the forms to review and go over, and then they can actually start filling out the forms before going to the courthouse if they prefer, or we assist people also in filing for their petitions. The Broward County Clerk also has the forms all online under their domestic violence division. They have the packets fully put together, so you can look at the forms there as well. There's absolutely no cost associated with any of these forms or any filing fees. So people can file it, without any cost. That's not something that's going to be a hindrance. It's a pro se process. So again, we could advise before filing or e-file the petitions, but it is set up to be a pro se process where by statute, the clerk does have employees that help the victims fill out their paperwork. So it's a verified affidavit. The petitioner is going to be writing out their petition and then signing their petition saying that what they have written is true. During COVID, a big question was, well, can I still file a petition for an injunction? And yes, you could. So injunctions for protection are considered essential. So a lot of times you've heard things like who's an essential worker, what's an essential service. Injunctions for protection are considered essential. During COVID, at the very beginning, you could only file at the main courthouse downtown. Now they have expanded it even, during the courthouse is still shut down really to the public, except for the clerk's office. But now they've extended it to the West Courthouse. So in the beginning, you could only go to Central. Now you can go to Central and West. So it is like before. The difference is that you have to tell the security guard or the deputy that's at the front that you are there to file for an injunction. And you have to wear a mask to enter the courthouse and observe, social distancing when you are at the courthouse. A really good way to check to make sure that you can still go to the courthouse is to look at the court's website. And I put that there. It's the 17flcourts.org. And I believe that it's being added to the chat as well. Or the clerk's website. They also have their information listed. If you know somebody or you are somebody with limited access to the internet, the court does have an emergency information telephone number. And I put that there as well. It's 954-831-7777. And that's also updated for things like hurricanes. We also had a hurricane scare during this COVID time. So the courthouse did close at 2 p.m. on a Friday, and you were able to call the phone number to find out when they would be reopening. So always look online. I think that the court's been very good about updating their information for everybody, and so is the clerk, and letting people know what's open and where to go and how to file. So filing, the initial process is ex parte. So what that means is that the court is only hearing from one side. So the petition, when the petitioner fills out the forms, it's going to be reviewed by a judge without hearing from the other side. So the petition can be denied once the judge reviews the allegations. The judge may say, no, I don't think that this person's in any kind of danger. I'm not going to grant a petition, a temporary injunction. So once they deny it, there's no protection offered. And then you can ask the clerk to file a supplemental affidavit in support of the petition. And in that, you would add additional incidents to still try to gain a temporary injunction. It may still be denied at that point. Sometimes the judge will issue what's called an order setting a hearing on the petition. That also offers no protection, but it will set the case for a hearing. You will also be given the option to withdraw the petition before the packet would go out for service on the respondent, because basically that would mean that the respondent, who's the opposing party, would have notice of all the allegations that you're stating against them, but would give you no protection. So sometimes that can be very dangerous. So the clerk has built in an option where you can withdraw that petition before it goes out. You can also supplement this petition if you get an order setting and try to add additional incidents in support of your petition. The third option is that you're going to be granted a temporary injunction for protection. So if the petition alleges sufficient facts of violence or stalking and the court believes that you are in danger, they can issue a temporary injunction. By statute, a return hearing should be set within 15 days. So if you get an order setting a hearing on the petition, that doesn't necessarily need to be set within 15 days, although it usually is. After a temporary injunction is issued, then a packet is put together by the clerk's office and sent to the Broward Sheriff's Office for service. So a packet's going to include the temporary injunction for protection, the notice of hearing. So in some cases, that's going to be on the temporary injunction, but if it's an order setting a hearing, then it's a notice of hearing, the petition for the injunction, and then if there are children or a child, then normally a petitioner also has to fill out something called a Uniform Child Custody Jurisdiction and Enforcement Act affidavit and a financial affidavit if they are asking for child support. So the Uniform Child Custody Jurisdiction and Enforcement Act affidavit, commonly called UCCJEA, basically just states where the child has lived for the past 5 years to make sure that the court, that Florida is the proper jurisdiction to hear this matter of anything related to the child. So again, all these forms are available online. So if you want to see the different forms that are used, I'm going to go through the domestic violence injunction form so that you can see what a petition for an injunction for protection against domestic violence looks like. And the other forms are similar, but a little different. So if you want to see those forms, please go online to see those. So this is what a petition for an injunction for protection looks like. And this is a packet that's on the clerk's website. So you can actually fill it in. So this is a PDF form that they put on there, and you basically just have to go through the different blanks and fill it in. So the petitioner would be the person who's asking for the injunction for protection. The respondent is the person that they want restrained. The case number and division would be assigned once the case is filed. And then basically it asks for information, the current address of the petitioner, although if the petitioner is living at a confidential location, it's really important that a petitioner identify their address as confidential so that it's not listed on any of the court documents. They have to give information about the respondent, any case history involving the parties. So many times we know that it may take a victim an average of 7 times to leave a relationship, and even more from, I believe those numbers were based on a white woman leaving a relationship. So we know that it's going to take many times to leave a relationship. So there may be a history, and the petitioner may have already gotten a temporary injunction before. Maybe they didn't show up to court. Maybe they had a final judgment, but they thought, oh, let me give it another chance. So the court wants to know about the history between the parties. On the left side of the screen, you see, and these are 2 separate pages, you see where there's a checklist, A through K. And those are all the different factors for the court to consider in deciding whether or not to grant a final judgment of injunction. So many times, a lot of these things are checked. Sometimes it's just a few things, but A is about previously committed or threatened to commit domestic violence as defined by the law. So normally that would be checked. Previously threatened, harassed, stalked, or physically abused the petitioner, attempted to harm petitioner or family members or individuals closely associated with the petitioner. So many times they don't just threaten the victim, but they also threaten the victim's family. If you don't come home, I'm going to go and kill your mother. Threatening to conceal, kidnap, or harm the children. That's very common. I've had cases where they pick up the children from school. They don't tell the petitioner where the children are located, or they threaten to take the children and you'll never see the children again. Intentionally injuring or killing a family pet. Unfortunately, this is very common. Using or threatening to use any weapons, and that's guns or knives, but even other types of weapons can be checked off there. physically restraining from leaving the home or calling law enforcement. That's very typical. That, and you'll see there's something about telephones as well, where they restrain a victim from being able to call the police or call for help. Any criminal history involving violence or the threat of violence, like I said, this is, many times when somebody's coming in for an injunction, it's not the first incident of violence. So there may be a criminal history involving domestic violence or other types of violence. Another order of protection issued. So like I said, many times there's a previous injunction that may even be within the state of Florida or even outside the state of Florida. So usually I ask my clients if they've lived in other states, if they had previous orders of protection issued in those states. Destroying personal property, and so that includes the telephone. Like I said, many times they take the phone, they smash the phone so that the person can't call 911. But a lot of times you're going to find that there's ripped clothing or other items that they destroy. They take pictures and picture frames, smash the pictures, rip up pictures, bleach or set clothing on fire, things like that. Unfortunately, a lot of those things do occur. And then K is basically a catch-all, where it's if they engaged in any other behavior or conduct that would lead the petitioner to have a reasonable cause to believe that they're in imminent danger of becoming the victim of domestic violence. So many times that's checked off, and it may be, something else like suicidal behavior, which maybe could fall under attempting to harm somebody closely associated with the petitioner, but also could be something else that would cause them to believe that they're in imminent danger. On the next page, on the right side of the screen, is where the petitioner is going to write out their story. So many times it goes on to additional pages, and you see that you can check off to indicate if you're attaching additional pages. So most of the time we start with the most recent incident and then we work our way back. Anything that the victim wants the court to consider in deciding whether or not to grant the injunction needs to be written down. If it's not written down in the petition, then the court cannot consider it. And there's a case that says the court is limited to basically the four corners of the petition. So the history of the parties is important, and it is a factor for the court to consider. So many times, even though maybe the last incident may not have been the worst incident, and the worst incident was maybe 2 years ago, it's important for the court to be able to consider the worst incident or one of those older incidents, because that also contributes to why the victim is so afraid now. So maybe, now it was a verbal threat, I'm going to kill you. But 2 years ago, the abuser had been arrested for, strangling the victim. It's important for the court to understand that there is a history here, and, the threat to kill now is important because, they actually tried to kill previously. Then there's a checkbox that goes down where the victim would write if there have been any reports previously to law enforcement, other acts that are included, if they're known to have any guns or weapons, if there's a drug problem, an alcohol problem, mental health problems, if they've ever been the subject of a Baker Act, if they're supposed to be taking medication, if they are taking their medication. Sometimes the answer to these is just unknown at this point when they're filing for the petition, but sometimes, our clients will say, oh, he went off of his meds. Like, this is because he went off of his meds. And so it's important that the court understands that this may be an exacerbating reason why these things are happening. And also when law enforcement goes to serve these, they understand that, this person is not on their medication. The next portion, and I'm not sure if you saw that said temporary exclusive use and possession of the home at the bottom. So in a domestic violence injunction, the court can address where the parties are living. So let's say the parties are married and they share a home. The petitioner can request to have exclusive use and possession of the home that the parties share. And then the court just asks them a few questions like, can you get another safe place to go? Or where can the respondent go, to have other housing if they're not in the home? and then how the home is either owned or rented and who it's owned or rented by. So you can request that in this petition. The other thing that a domestic violence petition will address that the other ones do not address is a parenting plan or time sharing for minor children. So even though the incident may have been stalking, let's say a spouse was stalking their spouse, if you file for a stalking violence injunction, that's not going to include the children, and the children are not going to be addressed by a stalking violence injunction. Whereas under a domestic violence injunction, the children can be addressed. So the victim would write down the names, the dates of birth for any children. The court on these forms does ask whether the children saw the domestic violence that's described, or were in the same place as where the domestic violence happened, but maybe didn't see it, or were not there but have seen previous acts or have never witnessed any domestic violence. This is important because many times the children are the only witness to these incidents, because these things happen at home. Who else is at home with people, especially nowadays when it's, people are really kind of quarantining at home with just their immediate family. Sometimes the children are the only witnesses. And it also may bring child protective investigations in if they believe that the children have been affected or may have been victims themselves. So it also asks the petitioner to list any other children who were there. So sometimes there's children that are not of the relationship, but that also live in the home. And then they ask what the petitioner would like to do. So can the court do a temporary parenting plan? And that just basically means time sharing. In Florida, we don't use words like custody or visitation anymore. It's time sharing and parental responsibility. So it goes through some of those questions. You can also request that there be supervised time sharing. And then you can also ask for some temporary support. So if there are children, then, like I said, you would fill out that Uniform Child Custody Jurisdiction and Enforcement Act affidavit. And if you're asking for support, then you would also be filling out a financial affidavit. And then the petitioner can request money for child support, but then also if they are married, they can also ask for some temporary spousal support or alimony. And then at the end, this is basically where you're summing up what you're asking for and saying, okay, we want a temporary injunction, that we're asking that a hearing be held, that we want to prohibit the respondent from going within 500 feet of where the petitioner lives, works, goes to school, or is, employed anywhere where they move. Don't contact the petitioner, mail, email, telephone, fax, through another person, going within 100 feet of the vehicle, destroying any personal property. You can add additional addresses. So many times this is going to be like a daycare or a school. Exclusive use and possession of the home. Again, that's only under the domestic. Time sharing, only under domestic. Parenting plan, only under domestic. Alimony and child support, also only under domestic violence injunction. So like I said, this is a verified affidavit. So the petitioner will have to actually sign this, saying that what they are writing in this affidavit is true. At the top there, you see that there's a couple other things that the petitioner can request, including treatment and counseling, and then a referral to a certified domestic violence center. So the other forms that would need to be filled out by a petitioner are a cover sheet for family court cases, and that's just done at an initial filing. A notice of related cases, and this is where the petitioner would let the court know about any other cases involving the parties. So a prior injunction for protection, maybe there's a related divorce or a paternity case, or a criminal case even. Then you can write that on there. There's also a respondent description information sheet, and that's where the petitioner is going to write out where they think that the Broward Sheriff's Office or a law enforcement officer would be able to serve the respondent. They also do ask that you fill out a notice of social security number. The clerk then will also do an affidavit of any related cases. They'll do their own search. And then there's also a request for confidential filing of the address. So in the beginning, you heard me say, if you're staying at a confidential location, you do not want that disclosed, then you should fill out a confidential filing of the address. There's also a petitioner's waiver, and I'm going to show you what that looks like and how you want to proceed. And again, if children, you're going to be filing the UCCJEA, and if you request support, a financial affidavit. So on the left, you'll see this is called a petitioner's waiver. And so many times, a petitioner may spend a couple of hours filling out all this paperwork at the courthouse, and they don't want to sit and wait for a judge to review it. So they can elect that either they're going to come back to pick up their order or that then it would be mailed. So they're going to check off whether they plan to pick it up or if it will be mailed to them at the address. On the right-hand side is how you want to proceed if the court does not enter the temporary injunction. So in the beginning, remember I said, when you fill out a petition, it could be denied. You can get an order setting a hearing or a temporary. So this is basically saying, okay, if the court does not enter that ex parte temporary injunction, what do you want to happen? So do you still want that order that sets a hearing on your petition where the service packet's going to go out to the respondent and then they'll be served with the allegations against them, but no protection is offered? Or do you just want to withdraw it, basically deny everything? So they do ask the petitioners to check off what they want to do. And you can see, on B that it says, I do not want the respondent to receive a copy of my petition and a notice of hearing. So again, you can always supplement if you don't get a temporary injunction, so you can try to get one, but you will be given the option to withdraw it also. So some of the frequently asked questions we get about this is, well, what if I don't know the respondent's contact information or if the respondent is quarantined? And if you don't have a phone number or email or anything like that, and the respondent is not served and the court can't prove that the respondent was served with notice, then you would ask the court to extend your temporary injunction they usually do it about 30 days, and reset the hearing to give law enforcement more time to serve the respondent. So many times these quarantines are 14 days. So most likely a hearing that has to be set within 15 days is not going to give law enforcement enough time to serve a respondent. We've even had where respondents are incarcerated and quarantined because of COVID. And even within the jail, they're not able to serve somebody because they're in quarantine. So you may just have to ask for more time in order to give law enforcement the opportunity to serve those petitions and the temporary injunctions. So right now, hearings are being held through Zoom, and I'll talk a little bit more about that. But if you can't attend through Zoom or phone, then it's really important that you contact the judge or the case manager, the judge's assistant, because they'll try to get in touch with you to give you this information. But if you do not appear for court, either on telephone or Zoom, then the injunction may be dismissed. So it's really important that a petitioner keep the court updated with any changes to their contact information and inform the court if the information is to be kept confidential. We tell people to be available for a little bit of time before the hearing and then for at least a couple of hours after the hearing time, because the court does run late. You may be waiting for a couple of hours also to get into court. So usually the court does want to see you on camera because they need to administer the oath. They'll say, raise your right hand. Do you swear to tell the truth, the whole truth? And they need to see you to be able to administer that oath if you're not present with a notary, next to you. So if it's something where you can't appear on camera, then it's really important that you do contact the judge's office so that they understand that you can only appear by phone, and they may need to reset your hearing. So all the judges have included their Zoom information in their procedures that are located online on the 17th Judicial Court's website. And they have their courtroom links, and they also have their procedures on there. And so many of them will have procedures like contact my office at this number if you cannot if you cannot appear, or this is an email address. Please email this address if you cannot appear. So you will want to check your judge's procedures, and the link to their courtroom will be there. But it should also be on your temporary injunction or your notice of hearing. So the temporary injunction, once it's issued, you'll be assigned a case number, and your names will be on there. It will have a notice of hearing with the date, the time, the courtroom, or the Zoom link, and the judge's name. This is where our office comes in. We represent people at these return hearings. The temporary injunctions will prohibit all violence and all contact, and that's direct or indirect. So as I said before, that's email, mail, fax, telephone, through another party. You can't have somebody contact the victim on your behalf. Respondent cannot go within 500 feet of the residence, the workplace, or anywhere where the petitioner or the minor children go often. No firearms, ammunition, or concealed weapons permit. Again, they can award temporary exclusive use and possession of the home under a DV injunction, a domestic violence injunction, temporary time sharing, and usually the court will give 100% to a petitioner until a hearing, unless maybe there's a prior court order that addresses time sharing. And the temporary injunction is enforceable by arrest. So that means if the respondent does violate the temporary injunction when they've been served, they can be arrested for those violations. So, important questions. Like I said, we are hearing these cases via Zoom. So many times people are like, but the courthouse is closed. How is the judge going to hear my case? Again, injunctions for protection are considered critical. We are essential. So the judge may proceed with these hearings via Zoom, and the court has been proceeding with these hearings via Zoom. So again, there's the list. You can look up your judge. You can look up their Zoom courtroom and any of their procedures. So how injunctions get served? So once you get that temporary injunction, it needs to be served on the other side. So under the law, this is the statute. So it has to be served by a law enforcement agency. So our clerk of court does send the packets to the Broward Sheriff's Office, who they have a civil division. That civil division does send out the packets for service. So they have to serve the petition, a financial affidavit if there is one, the UCCJEA if there is one, and then the notice of hearing and temporary injunction. That's what needs to be in the packet. So law enforcement must serve that. And when it is served, they may also accompany the petitioner and assist the petitioner in gaining possession of the residence. So sometimes the parties are still living together. Petitioner goes and files for the petition and is granted a temporary injunction. Well, they know where their respondent is. The respondent's back at home. They can contact their local law enforcement officer to go with them to the home, and they're given an emergency service packet. So it's like a manila envelope with tape around the top that the clerk prepares for them. And that law enforcement officer is supposed to accompany the petitioner and assist in placing them in possession of the home with that emergency service packet. But it's really important to understand that no process servers can serve these injunctions. It has to be a law enforcement officer. So sometimes we get respondents who maybe avoid service, but usually you cannot have a process server serve these. I say usually, sometimes you can get a court to issue an order for that, but by statute, it must be a law enforcement officer. So I wanted to also give some Zoom hearing tips, because these hearings do appear to seem like they will be on Zoom for a while. So like I said, you have to appear on camera to actually be administered the oath. So some people just use their smartphones. If your smartphone has a camera on it, you can use that. A tablet, a computer, but you will need to turn the camera on. I do suggest that you do a practice session. And I know many times with our office, our attorneys are meeting with the clients and having those practice sessions on Zoom ahead of time. Obviously, dress appropriately for court. It is still court. Even though you're on Zoom, You do need to appear appropriate for court. So that means, as well, like not smoking cigarettes while you're in court, or, lounging in a bed under the covers. You should be sitting up proper, dressed appropriately for court. Solid colors appear best on these cameras, so I would suggest that. When you sign in, it's really important that you use your full name to sign in. If you don't log in with your name, then they may just either leave you in the waiting room or say that you did not appear. When you log in, you may go into something that they call a waiting room, where you're just going to wait until they pull you in, and there's no warning. So it's really important that you've, gone to the bathroom, you have a drink of water, anything you need to do is done before that. Make sure that there's nothing identifying, especially if you're at a confidential location. So be aware of what's showing outside of your window. You may want to change your background, like how I have our Coast to Coast Legal Aid logo behind me. Try to use a solid, plain background if you're going to use a background. Nothing distracting. If you get disconnected during the call or video, try to log back in right away or call back in immediately. They do have the call-in numbers on the notices. Contact the court right away if you have trouble getting back in. It's also really important that you're alone during your hearing. You can't text or communicate with anybody else. So it's as if you are on the stand in the courtroom. You can't talk to anybody else that's in the room with you. You cannot do that. If you have a child or children in your home, it's really important that you're in a separate room for your hearing so that the children do not hear your testimony. Obviously, the nature of these hearings, is something that they should not be hearing about, especially if the abuser is the children's father. You don't want to expose your children to that information unnecessarily if they possibly don't know about it. If you do need to supervise a child and you don't have anybody who can watch the child, you really should let the court know. Perhaps they could reschedule you for a time when you would have childcare. So for that final hearing, whether it's on Zoom or in person, at the final hearing, the judge is going to ask the respondent if they would agree to the entry of a final judgment or if they would like a hearing. If they agree to the entry of a final judgment, then you pretty much just go on to talk about the terms of the injunction. But if they have a hearing, then you're going to have to go through an evidentiary hearing where the court's going to take testimony and consider evidence. So if there's a hearing, testimony will be given, and usually it's the parties or any witnesses that actually have personal knowledge of the alleged incident. So you can't just have somebody come in to say, oh, she's a great mom, or oh, he's a good guy. That's not going to happen. They have to have personal knowledge of the incidents alleged in the petition. So a lot of times there are companion criminal cases that arise out of the same allegations in the petition. So officers many times are subpoenaed to appear in court, and they can testify. Maybe they weren't there for the actual incident. Sometimes they are. But if they weren't, then they can always testify about what they observed when they arrived on scene, injuries and damage to property, the demeanor of the parties, had somebody been drinking, or any admissions made, and then whether or not they, actually arrested anybody due to this. Like I said before, many times there aren't witnesses to domestic violence because of the nature that, normally it's at home and outside the view of other people. So it's not uncommon that you wouldn't have another witness. So, many times my clients are so concerned that they don't have any witnesses, but I tell them that that's very normal. And the judges understand that as well. So other evidence that can be used are obviously the pictures of any injuries, broken phones, ripped clothing. But again, it's also very common for a victim not to have any evidence. We do encourage victims to take their own pictures of their injuries, because many times, even if the police responded and took pictures that night, many times bruising doesn't show maybe for a day or two. So we always ask them to take pictures themselves, and then also to email it to themselves or a trusted family member or a friend. Obviously, if we're on the case, they would be emailing it to us. But many abusers will delete photos if they're stored in a cloud, or sometimes if they have access to their victim's phone, either through a spyware program or just hacking into the Apple ID or something. then they may try to delete things off of the phone. So at the final hearing, after hearing testimony from both sides, then the judge is going to make a decision about whether or not to grant an injunction. So if the judge feels that the petitioner has proven that she, he, they have been the victim of domestic violence, again, as defined by the law, or if they have a reasonable cause to believe that they are in imminent danger of becoming a victim, then the court will grant the injunction. Dating violence, they have to prove that they've been the victim of dating violence and that they have reasonable cause to believe that they're in imminent danger of becoming the victim of another act. And that's because, in a dating relationship, there's no children that keep them tied together. There's no property that's keeping them tied together because they didn't live together. So you have to show that something else is going to happen in the future. Stalking and cyber stalking, you have to prove that you've been the victim of stalking or cyber stalking. Same with sexual violence, repeat violence, again, that you've been the victim of at least 2 incidents, 1 within the past 6 months. So after the hearing, the judge can grant the final judgment of injunction or deny it and dismiss the temporary injunction. Dismissals are without prejudice, which means that if the petitioner ever wanted to refile for a new petition, they could allege any new incidents that the court did not rule on. So sometimes somebody will voluntarily dismiss before a hearing, and then if they need to refile at a later date, they can allege all the previous incidents and any new incidents, as long as the court hadn't heard them yet. So the terms of a final judgment, again, it could be entered by agreement or an evidentiary hearing. All the same terms that are in that temporary injunction are in this, with the added possibly temporary time sharing, exclusive use and possession, child support, and then ordering substance abuse evaluation if necessary, a batterer's intervention program, which is a 26-week program, mental health evaluation treatment. Really, the judge could order either of the parties to complete any type of counseling or program that they deem necessary. The temporary, all violence and contact is prohibited in a final judgment. You would add in any other addresses that need to be included, and no firearms. The final judgment obviously is also enforceable by arrest. So people can report the violations to the clerk of court or the state attorney's office, or just make a police report. So this is really important. Victims cannot violate their own injunction for protection. So an injunction for protection only restrains a respondent. It does not restrain a petitioner. Obviously, it could be grounds for maybe why a petition should be dismissed or why an injunction should be dismissed, but a petitioner can't be arrested for trying to contact their respondent. It's only the respondent who can violate. Another thing, when there is also a criminal case, there's usually no contact order as part of a pretrial release or as part of a probation. And it may also be a violation of a criminal no contact order or tampering with a witness, which is an extra criminal charge if there is a violation of the injunction. So Coast to Coast Legal Aid, like I said, we do represent people for their injunctions for protection against domestic violence. We also do any intimate partner violence or seniors who need help with injunctions for protection. We also can represent people for their divorce cases or paternity cases. We have a senior unit that helps people age 60 and over with basically any of their issues, including injunctions for protection, but also any housing or foreclosure issues or benefits, consumer issues, naturalization. We have an economic advocacy and community health unit as well, and we call them EACH, and they help with benefits, reemployment assistance, veterans benefits, Medicaid, Medicare, affordable care information. We have some special units. We have a rights unit, which helps survivors of human trafficking. RISE, which is a victim rights enforcement for the criminal case. So many times there, like I said, there's also a criminal case. We can help the victim go into the criminal case and enforce their rights through that case. We also had family court advocacy at the main courthouse during COVID. That's been closed. I have our website here, and I believe it's been put into the chat. You can always visit our website for more information. And so just the types of cases that we handle, we do holistic representation. So we try to do a legal checkup for our clients at the beginning of their application. We do injunctions, dissolution of marriage, paternity defense. We do housing issues, public benefits, immigration, like I said, enforcement of victim rights, and other legal issues. So like I said, we do try to do a legal checkup, and many of our clients, an injunction for protection is not their only legal need. So we do try to address everything holistically. So another big question is, how can you apply while we're closed? We are working remotely. So we do still take applications. Our application is available for download on our website, or you can call the phone number 954-736-2495 to apply for services. Our main number, which is also on the website, is 736-2400. If somebody is a victim of a crime other than intimate partner violence or senior, then there's another legal aid in Broward County, Legal Aid Service of Broward County, and they represent victims of crime for other injunctions for protection or other legal issues. So their website is there as well, browardlegalaid.org, and we work closely with them. Their phone number is 954-765-8950. So that's pretty much it. If there are any questions for me, I know that Sebastian's going to take those questions in the chat box. I want to thank the Broward County Library for inviting us here to do this during Domestic Violence Awareness Month. I think that it's great that you're educating the community on the services that are available, and we appreciate that.
Thank you so much, Mindy, for a great presentation, for your information and your time. And we do have one question, which is a two-parter. Do you think the wheel of violence, and in parentheses it says control psychological, is relevant when kids are removed and family is in the dependency system? And then the second question, or the second part, is when the judge has to decide placement/custody of the children.
Okay, so it's a little bit different. So dependency court, and I don't really practice in dependency court, so I'll give that disclaimer. But in family court, when deciding where a child is going to spend the majority of their time, or who should have parental responsibility to make major decisions for the children, the court will consider domestic violence. It's actually one of the factors for the court to consider under Chapter 61. So the court can consider prior convictions for domestic violence, injunctions for protection for domestic violence, and can even consider domestic violence when there was no prior criminal case or an injunction for protection. So it's considered a detriment, the existence of domestic violence to children in a family case. And obviously, domestic violence is one of the major reasons that children are removed for dependency cases. So, well, I don't practice in dependency. I hope that answers your question.
Thank you. And that's the only question we have so far. So if we don't have any other questions, I'm going to take advantage of this time to promote the program. This same domestic violence and legal systems session will be available in Spanish. And I put the link in the chat box, and that's on October 8th. From 3:30 to 4:30. So if you have anyone who is interested in this information and would like for it to be in Spanish, please share that link with them. And then also I shared a SurveyMonkey link. If you have time to share your feedback, we would love to hear what you have to say. And thank you again, Mindy, so much for your time and your information. And I hope everyone stays safe, and thanks for joining.
Thank you.
Thank you. All right, everyone, take care. I will be sending the recording via email, and I will also be including the links that Mindy mentioned and shared with us in there. Just this information is current to October 2020, so it is subject to change, and I'll be making sure to mention that in the email, and it's also part of the presentation. All right, thank you everyone so much. Take care.